It's a little bit lengthy judgment. I will be reading only the relevant portions. The West Bengal Central School Service Commission, hereinafter referred to as the Commission in short, by a notification bearing number such and such dated December 16, 2016, had announced the state level selection test for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored schools in West Bengal, hereinafter referred to as the first SLST 2016 in short. The petitioners of this batch of writ petitions had participated in the said selection test but were unsuccessful. The petitioners are challenging the said selection process on the grounds that it is vitiated by corruption and malpractices of the respondent authorities. They are also challenging the legality and validity of the order of the School Education Department, Secondary Branch, Government of West Bengal, bearing number such and such dated May 19, 2022, so far as it relates to creation of 1600 supernumerary posts of assistant teachers with breakup of 750 posts of work education and 850 posts of physical education teachers to appoint all waitlisted candidates of the said first SLST 2016 under the said two categories, and the notices bearing number such and such dated October 14, 2022, whereby the Commission had notified the dates of counseling for filling up the said supernumerary post. In order to afford opportunity of being heard, the said waitlisted candidates were notified. Some of them had applied for their addition in one of the writ petitions, being WPA 25056 of 2022, except one being CAN 11 of 2025, which was not moved. All applications were allowed. In consequence, the applicants of those applications have been added as respondent number 7 to 301 in the said writ petition. The legality and propriety of first SLST 2016 and the said two notifications are under challenge in the writ petition. The added respondents, in terms of the said notification dated May 19, 2022, have already recommended for appointment long back, but could not be appointed due to the interim order of stay passed in one of the writ petitions. Therefore, there is an imminent urgency in deciding the challenge to the said notification dated May 19, 2022 and October 14, 2022. As such, the said challenge is taken up for consideration independently first, keeping the other dispute issues raised in the writ petition pending. The state and the added respondent at the threshold have raised an objection as to the locus standi of the petitioners to maintain the writ petitions, particularly to throw challenge to the said notification dated May 19, 2022 and October 14, 2022, as the petitioners are unsuccessful candidates of first SLST 2016. Therefore, the first issue falls for consideration in the matter is thus whether the petitioners, being unsuccessful candidates of relevant selection tests, are entitled to challenge the notification dated May 19, 2022, and whether such challenge is barred by limitation. The issue being related to maintainability of the writ petitions, the respondent have the right to begin. The argument of the learned counsel for the parties to on the said issue are recorded herein below in seriatim. Now the argument of is starting from this respondent's argument, Mr. Sengupta onwards. I have recorded the submissions of all parties. Then Mr. Vikas Ranjan Bhattacharya, petitioner. मुश्किल The next issue, the second issue, calls for consideration is as follows. Whether the creation of supernumerary posts to give appointment to the Westlisted candidates of the panel of first SLST 2016 in the post of assistant teacher for the subject work education and physical education in upper primary level of school is legally sustainable. Then again, according to the argument of the learned counsel for the parties, on the second issue are recorded herein below in order of their appearance. Now, the court on first issue. The Honorable Supreme Court in the case of Dharanidhar Mishra Supra, cited on behalf of the petitioners, has observed that in a case where the demand for justice is so compelling, a constitutional court would exercise its jurisdiction with a view to promote justice and not to defeat it. Keeping the said object in view, the issue of maintainability is addressed. The decision of learned single judge of this court in the case of Ganesh Chandra Mukherjee, cited on behalf of the respondent, is completely irrelevant to decide the issue, inasmuch as in the said decision objection was taken as to the jurisdiction of the court to maintain an application uh, under Article 226 of the Constitution of India Constitution against a company, which such is not a challenge here. I am at one with Mr. Bhattacharya that to decide the issue of maintainability of writ petitions raised by the respondents, the averments made in the writ petition must be taken to be true and correct. If the said test is applied, the issue of maintainability vis-a-vis the locus standi of the petitioner cannot be decided at the threshold as a preliminary issue. The Honorable Division Bench in MAT 723 of 2025, while affirming the order of injunction passed by this court, had never directed the said issue is required to be heard first, deferring the decision on merit. Therefore, I am unable to convince myself to accept the argument of Mr. Sengupta that the issue of maintainability should be decided as a preliminary issue, particularly when the said issue raises a mixed question of law and fact. To answer the issue under consideration, it is necessary to understand the scope of present writ petitions. The petitioners are challenging the legality and validity of the entire first SLST 2016 so far as it relates to the recruitment of assistant teachers at the upper primary level of recognized non-government aided sponsored schools in West Bengal for the subject physical education and work education on the grounds that the said selection test is initiated by malpractices, illegal actions, and manipulation of the respondent authorities. The petitioners, though, have participated in the said selection test but were unsuccessful. As such, their locus to maintain this said challenge is questioned. There, there was another recruitment drive conducted by the Commission in the year 2016 for recruitment of assistant teachers for class 9, 10, 11, 12, Group C, Group D post. In several writ petitions, the said selection test was challenged on the self-same grounds of fraud, illegality, and malpractices of the authorities. The challenge was sustained. As a consequence, the entire selection process was set aside by the Honorable Division Bench of this court in the case of Boishaki Bhattacharya. The said decision was affirmed by the Honorable Supreme Court. In the backdrop of such facts and circumstances, it will not be just and proper to dismiss the writ petition at the threshold on the ground of maintainability without verifying the veracity of the allegations made therein. The petitioners are alleging the fresh vacancies have been created in the name of supernumerary courts. As such, all participants in the said relevant selection test have a right to be considered against those vacancies. The allegation needs to be investigated on merit, and without such step being taken, the writ petitions cannot be dismissed on the ground that the petitions being unsuccessful in the relevant selection test have no locus standi to maintain the writ petitions. The Honorable Division Bench of this court, in the case of Boishaki Bhattacharya Chatterjee, while overruling the similar objection, had observed at paragraph 163 that writ petitioners are participants of the selection process, albeit unsuccessful by most, but they are entitled to fair consideration in the selection process. The said paragraph is quoted below for ready reference. Then 163 quoted. The Honorable Supreme Court in Vidya Devi versus State of Himachal and others reported in 2022 Supreme Court cases 569 has held that delay and laches cannot be raised in a case of continuing cause of action or where the facts shock the judicial conscience of the court. Moreover, there is no period of limitation for courts to exercise constitutional jurisdiction to do substantial justice. The action complained of shocks the judicial conscience of this court, inasmuch as the state, by the impugned notification, has sought to inject life into a dead panel. Such action of the state is not legally sustainable. The present context demands consideration of paragraph 147 of the decision of the Honorable Division Bench in the case of Boishaki Bhattacharya. 147 quoted, no appointment can be made after expiry of the panel, as the panel is not a perennial reservoir for appointments. Panel is valid for the declared vacancy and for the specific period. Appointment towards future vacancies cannot be made from the panel. Appointments made in violation of Article 14 and 16 of the Constitution of India are a nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of panel. Therefore, in the facts and circumstances of the present case, the alleged delay and laches are no fetter to maintain the present challenges. The decision cited on behalf of the respondent in the case of Aflatun and others versus Chennai Metropolitan Corporation in Murugeshwan are therefore factually distinguishable. The petitioners had participated in the relevant selection test, though unsuccessful, but they cannot be said to be totally strangers to the said selection process. In view of the nature of allegation and relief claimed in the petitions, the petitioners cannot be thrown overboard on the allegation of not having locus standi without addressing the said allegation on merit. In view thereof, the proposition of law laid down in the following decision on the point of locus standi to maintain the petition cited on by the respondents in the case of Ayub Khan, Tridevi, Himanshu, Gyan Shabai, Tajbir Singh, etc., are not applicable in the present case, inasmuch as in all those decisions, the Honorable Supreme Court had decided the said issue upon consideration of the cases on merit. In case of Bombay Dyeing, Supra, and in case of Taibai, the issue was relating to the grant of an order of injunction and the maintainability of the lease, which is not the issue under consideration. Therefore, the said decisions are not relevant to the context. In the case of Chandrakanto Ganguly, the Honorable Division Bench of this court has held that when executive action of the state is challenged, the court must tread with caution and should not overstep its limit, but with the further observation that the court is warranted only when there is oblique motives and miscarriage of justice. Petitioners have alleged both. It has already been held that the step taken by the state to give life to an expired panel prima facie is not legally justifiable. Therefore, the said decision cited on behalf of the respondent is of no help to them. It is not the validity of the decision, but the validity of the decision-making process to create supernumerary post is under challenge. Therefore, the said challenge is open to judicial review. The premise of the challenge being different on the decision of the Honorable Division Bench of Delhi High Court in the case of S.S. Goel is not applicable in the present case. In view of the above discussion, the first issue was answered affirmative. The petitioners have locus standi to maintain the writ petitions and are entitled to challenge the notification dated May 19, 2022 and October 14, 2022. The court on the second issue. The Government of West Bengal Education Department Secondary Branch by a notification dated September 2016 had framed the rules regulating the manner and scope of selection of person for appointment to the post of teachers for upper primary level of schools, namely the West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of school rules 2016, hereinafter referred to as the said rules of 2016 in short. The commission, being designated by the said rules of 2016, had notified first state level selection test, the first SLST 2016 in short, for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored school in West Bengal, wide notification bearing number such and such dated December 16, 2016 against the vacancies available under the said rules of 2016. The relevant portion of the said recruitment notification dated December 16 is quoted below for ready reference. Emphasis has been supplied against vacancies available under the West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of school rules 2016. The said rules of 2016 prescribes a complete mechanism for selection of persons for appointment to post of teachers for upper primary level of schools. The Rule 8 thereof lays down the procedure as to how the vacancies for such recruitment process would be ascertained. The said rule prescribes that the district inspector of schools, on being asked by the director of school education, shall prepare a report regarding the number of vacancies in posts and shall send it to the director of school education. The said director, on receipt of such report with due approval from state government, shall send it to the central commission. Firstly, before the date of publication of advertisement, before inviting application. Lastly, 15 days from the date of publication of the result of the written examination or interview list, as the case may be. The relevant portion of Rule 8 of said rules of 2016 is quoted below. Then Rule 8 is quoted. Rule 16 of the said rules of 2016, apart from mandating that each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next recruitment process, whichever is earlier, by virtue of the proviso thereof, also stipulates that the names of candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified in terms of sub-rule 3B of the Rule 8 of said rules of 2016. Relevant portion of the Rule 16 of the said rules of 2016 is quoted below. Clause 11 of the recruitment notification dated December 16, 2016 reiterates the said mandate of the said rules of 2016. The same is also quoted below. The position of extant rule, as it appears from the above discussion, is that the recruitment drive was initiated to fill up the vacancies available under the said rules of 2016. The Rule 8.3 thereof fixes the time limit within which such vacancies are required to be ascertained and reported to the Commission, but the said procedures were not followed in creating the vacancies for the waitlisted candidates of first SLST 2016. The state has created the said vacancies in the name of supernumerary post with the approval of the committee. The petitioners in WPA 25056 of 2022, by way of supplementary affidavit, have brought the cabinet memorandum bearing number such and such dated May 5, 2022 on record. The Principal Secretary of the Government of West Bengal School Education Department, by the said memorandum, inter alia had proposed to create 1600 supernumerary posts with breakout of 750 and 850 for absorption of all waitlisted candidates of first SLST 2016. To understand how the said vacancies in the name of supernumerary posts were proposed to be created, the said cabinet memorandum dated May 5, 2022 demands a close look. The said memorandum records the proposal of the Central School Service Commission for creation of 5,261 posts. The relevant portion of the said proposal is reproduced below. Then it is reproduced. The said memorandum thereafter records the proposal of the Commissioner of School Education to create 1600 supernumerary posts, breakup of 750 and 850. To absorb all waitlisted candidates of physical and work education subject to validation of panel. The relevant portion of the said proposal is reproduced below. The following views of the School Education Department of the West Bengal Education Department, Government of West Bengal on the said proposal are recorded in the said memorandum. Then what was their proposal? The no objection of the Finance Department has been recorded in the said memorandum, which was subject to the approval of Cabinet and adherence to the extant rules. The said memorandum ultimately records the proposal of the Department of School Education to create supernumerary posts. The said proposal is reproduced below for ready reference. It is clear from the above discussion that the aforesaid vacancies in the name of supernumerary posts have been created without following the said rules of 2016, particularly Rule 8 thereof. As such, the said vacancies are apparently new vacancies. Consequently, it cannot be exploited to give appointment to the waitlisted candidate of the panel of first SLST 2016, inasmuch as proviso appended to Rule 16 of the said rules clearly stipulates the names of candidates shall not be recommended against any vacancy which has not been notified in terms of Sub-Rule 3B of Rule 8 of said rules of 2016. The Honorable Division Bench of this Court in the judgment dated April 22, 2024, passed in Boishaki Bhattacharya Supra, had directed the CBI to undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary posts to accommodate illegal appointments. If necessary, shall undertake custodial interrogation of such person involved. The Honorable Supreme Court, in its order dated April 8, 2025, passed in Civil Appeal number 4800 of 2025, arising out of the said judgment of the Honorable Division Bench, had set aside the said direction for investigation into creation of supernumerary post, with a clarification that the observation and direction made in the said order are limited to the extent of such direction of the Honorable Division. The relevant portion of the said order of the Honorable Division Bench is quoted below. This is the Supreme Court. Is quoted below. The Honorable Supreme Court, by the said order dated April 8, 2025, had never put a restriction to look into the legality and propriety of the creation of such supernumerary posts. Therefore, the present challenge is no way affected by the said order. The state has sought to justify the creation of the said vacancies in the name of supernumerary posts on the ground the state is obliged to fulfill the constitutional mandate of Article 21, capital A, to provide free and compulsory education to all children of the age 6 to 14 years, and to follow up legislation, the Right to Education Act 2009, puts the state under the obligation to provide adequate number of teachers to the schools. As such, it has taken a decision to create supernumerary posts to absorb the waitlisted candidates of first SLST 2016 to meet a special exigency. The same being a policy decision is not open to judicial review. The said justification is not tenable inasmuch as it is a settled position of law that policy decision is not open to is open to judicial review if it is found to be arbitrary, unconstitutional, and in violation of the statutory provision. Of course, cautious approach is needed when such policy is based on cabinet decision, as has been held by the Honorable Supreme Court in the case of Himachal Pradesh Niji Vishayak Parishan Kendra Sangha Supra, cited by Mr. Kalnan Bandyopadhyay, learned senior advocate for the respondent number 289 to 301. However, in the present case, even if the said test is applied, this court cannot foreclose its jurisdiction of judicial review under Article 226 of the Constitution, as the decision is arbitrary and in complete violation of the extant rules. In the backdrop of the decision cited by the learned Advocate General in the case of Bhikari Charan Kuntia, Pushpa Rani, official liquidator, and Lieutenant CDR M. Ramesh are of no help to the state. In this context, the observation of the Honorable Supreme Court in the case of Manohar Lal Sharma at paragraph 14 being relevant are quoted below. On matters affecting policy, this court does not interfere unless the policy is unconstitutional or contrary to the statutory provision or arbitrary or irrational or in abuse of power. The Honorable Supreme Court in the case of BP Singhal and SR Mumbai has held that though no reason to be assigned for the discontinuance of the pleasure resulting in removal of governor, but even then the power under Article 156(1) of the Constitution is open to judicial review if such power is exercised in an arbitrary, capricious, and unreasonable manner. No doubt the state has the obligation to achieve the constitutional mandate enshrined under Article 21A, but to get it, the state cannot compromise with the rules and regulations framed to regulate the appointments of the teachers. In the present case, such compromise has been made to give appointments to the waitlisted candidates of an expired panel. The argument of the learned Advocate General that a discretion can be exercised for creation of supernumerary posts to promote the object and purpose of 21A of the Constitution, Article 21A of the Constitution, without taking recourse to a fresh selection process cannot be accepted for the reason that such discretion has been exercised in an arbitrary manner in violation of the relevant rules. The vacancies so created in the name of supernumerary posts, since are new vacancies, those are required to be filled up in the new selection process. The petitioners, being eligible, had participated in the first SLST 2016 but could not qualify. However, with their such eligibility, they are subject to age bar, entitled to participate in the next selection process to offer themselves against those new vacancies. But the petitioners, in view of the decision of the state to exploit the said vacancies to accommodate the said waitlisted candidates of the earlier selection test, that is first SLST 2016, have lost the said opportunity. The said decision, therefore, certainly offends the constitutional schemes of Article 14 and 16. The Honorable Supreme Court in the case of Raj Kishore Nanda has held that it is settled legal position. The vacancies cannot be filled up over and above the number of vacancies advertised, as the recruitment of the candidates in excess of the notified vacancy is a denial and deprivation of the constitutional right under Article 14, read with Article 16(1) of the Constitution, of those persons who acquired eligibility for the post in question in accordance with the statutory rules subsequent to the date of notification of the vacancy. In this backdrop, the argument of the respondent that the petitioners being unsuccessful and waitlisted candidates being successful, the waitlisted candidates being successful in the first SLST 2016 are wholly different classes. As such, there is no infringement of Article 14 of the Constitution is misconceived. Therefore, the challenge to the locus standi of the petitioner to maintain the writ petition and to throw challenge to the impugned notices is overruled. The creation of vacancies in the name of supernumerary posts have been sought to be justified from another angle, that is, state in exercise of its executive power vested in it under Article 162 of the Constitution can create such vacancies. The said justification is not tenable in as much as the executive powers so vested are subject to other provisions of the Constitution. In other words, executive powers cannot be exercised to defeat the right to equality guaranteed under Articles 14 and 16 of the Constitution. The decision of the Honorable Supreme Court in Rai Sahib Ram Jaya Kapoor and the decision of the Honorable Division Bench Sharad Kumar Singh have explained the scope of executive power under Article 162 of the Constitution. There is no dispute that executive power of the state shall extend to the matters with respect of which to which the legislature of the state has power to make laws, but exercise of such power is not immune from judicial review when it is done arbitrarily, capriciously, or unreasonably. The decision of the Honorable Supreme Court in the case of Samser Singh and Hurinath, cited by learned Advocate General, is on the issue regarding extent of power of governor in conducting the business of the government under Article 166(3) of the Constitution, but the issue is nowhere connected with the present issues under consideration. The Cabinet Memorandum dated May 5, 2022 has recorded grievances of the candidates in the recruitment process of first SLST 2016, which inter alia indicates that the proposal of creation of such vacancies was to instill confidence in general public in the matters pertaining to education and involving public environment. It is rightly submitted by Mr. Bhattacharya, a senior counsel for the petitioner, that constitutional morality must prevail and cannot be replaced by political morality. Paragraph 146 of the decision of the Honorable Supreme Court in the case of Srinath Balasaheb Patil being relevant to the contest is quoted below. Contention of the respondent that the political exigencies required such measures to be taken needs to be rejected. The constitutional silences cannot be used to introduce changes of such nature. The Honorable Supreme Court in Chandan Banerjee has noted the following definition of term supernumerary post from Oxford English Dictionary: present in excess of the normal or requisite number, or not belonging to a regular staff but engaged for extra work. A supernumerary post is defined a post exceeding the usual stated or prescribed number. There is no dispute with regard to the nature of supernumerary post. A supernumerary post is a temporary additional position created for a limited time to accommodate an employee when a regular post is not available. The Cabinet has approved the proposal as contained in a Cabinet memo dated May 5, 2022 to absorb waitlisted candidates of first SLST 2016 in the vacancies created in the name of supernumerary post. Therefore, conceptually, the supernumerary post is a post to be created to absorb an existing employee when such employee could not be accommodated in a regular post. There is no dispute with regard to the proposition of let down in the case of Horen Borgian, cited by Mr. Kalyan Bandyopadhyay, that supernumerary post denotes creation of temporary post outside the cadre personal to the incumbent. However, the said decision is of no help to the respondents. Decision cited by the learned Advocate General in the case of Pushpa Rani to contain the supernumerary post created at the same time in different cadres can also be constitute part of the cadre is completely irrelevant to the present issue. The waitlisted candidates of first SLST 2016 were not in employment. In fact, the panel and waitlist of the said selection test had expired long before the Cabinet approval of the proposal of creation of supernumerary post in the name of vacancies in the name of supernumerary post to accommodate the said waitlisted candidate. Interestingly, Finance Department, Government of West Bengal granted its no objection to the proposals to absorb, quote unquote, absorb the waitlisted candidates subject to the validation of panel. The cabinet was aware about the position that the supernumerary post cannot be created to appoint a person. As such, consciously used the word to absorb in the cabinet memorandum dated May 5, 2022. The Honorable Supreme Court in Devdotto Supra has held that the term absorbed in service jurisprudence with reference to the post implies that an employee who has not been holding a particular post in his own right by virtue of another recruitment or promotion to that post but is holding different post in a different department is brought to this post either on deputation or by transfer and is subsequently absorbed in the post with, whereafter whereafter he becomes a holder of that post in his own right and loses lien on the present post. Summing up the discussion made above, I am of the opinion that supernumerary post cannot be created to appoint the waitlisted candidates of first SLST 2016 for the subjects work education and physical education. In terms of the Rule 2013, the panel of first SLST 2016 was remained valid for 1 year from the date of publication of the panel of the waiting list or date of advertisement of the next recruitment, whichever is earlier. The recruitment notification dated December 16, 2016 also stipulated the same time limit for the life of the said panel. The panel has admittedly expired on December 11, 2019, long prior to the date of cabinet approval of the proposal of the School Education Department to create vacancies in the name of supernumerary post to accommodate the waitlisted candidates of the said expired panel. The Honorable Supreme Court in the case of B. Valluvan has held the life of panel, as is well known, must be for a limited period. It is governed by the statutory rules. The following extracts of paragraph 9 of the decision of the Honorable Supreme Court in the Jagadish Chopra being relevant is quoted below. Then paragraph 9 quoted, the decision of the Honorable Supreme Court in the case of A.P. Agarwal cited by the learned Advocate General is completely misplaced in the facts and circumstances of the present case, inasmuch as in the said case the validity of the panel was not extended. Rather, the second candidate of the panel was appointed in terms of the office memorandum as the vacancy had occurred due to the resignation of the first candidate within 6 months of joining. The order of the court cited on behalf of the state is of no help to the respondent. Rather, it supports the case of the petitioners inasmuch as in the said case, this court had dismissed the writ petition, accepting the submission made on behalf of the commission. The panel has expired long back. In the case of Gujarat State Deputy Executive Engineer Association, Supra, the Honorable Supreme Court has explained that a waiting list is in the present case. There is no issue on the what the waiting list is. In the present case, there is no issue on the validity of the waiting list. Therefore, the said case has no manner of application. It is settled position of law. Waiting list cannot be treated a perpetual reservoir for filling up the future vacancies. The argument of the respondent that the life of the panel stood extended due to the pendency of the litigation in respect of first SLST 2016 is completely unacceptable inasmuch as the selection process was conducted in terms of a statutory rule. The decision of the learned single judge of the Rajasthan High Court on behalf cited on behalf of the respondent number 289 to 301 in the case of Rambabu Kohli on this point is factually distinguishable. The Honorable Supreme Court in Sulekha Chandra has specifically held the appointment divorced these statutory rules is void of an issue. That being the position, I am unable to accept the argument of Mr. Sengupta that supernumerary posts have been created as a gap-filling measure since first SLST 2016 is governed by a statutory rule. Therefore, on this court, the judgment of the Honorable Supreme Court in the case of Kantri Ravi cited on top of the respondent number 7 to 207 is of no help to the said respondent. The decision of the learned single judge of this court in Saroj Karmagar is no pointer to the issue under consideration. Argument of Dr. Patro that the substantive post cannot be equated with the supernumerary post. As such, the rules of 2016 is not applicable in respect of the post created by impugned notification is completely fallacious in as much as the waiting list is in relation to first SLST 2016, a selection test governed by a statutory rule, that is said rules of 2016. The Honorable Division Bench of this court in Rajiv Brahma has dealt with first SLST 2016 for recruitment of assistant teachers in upper primary except physical and work education in government schools. Therefore, the said decision has got no manner of application in the present case. Conclusion: in view of the discussion made above, the impugned notices being dated 19 May 2022 and 14th October 2022 are set aside and quashed. The connected application can 11 is dismissed. There shall be no order as to court. Let the writ petition listed in monthly combined list of January 2026 for considering disposal of other issues involved in the writ petition. Black pen, black pen, এই ঝোলাতেও পারে সত্যি দর্শনীয়, এটাই জানেন। এটা দিয়ে দেবেন আর কারেকশন আছে কতগুলো, ফার্মে ঢুকান পরে দেখবে যে এই লাইভ বন্ধ করো, জল খাবো।
wanted that in Arjikor immediate. That's the directions after dealing all the points.
Oh, this is that. What is called?
So page 40. Kindly see the later portion after delivery. Yes.
Oh, counseling, deviation of counseling.
Yes. Deviation of.
Then what happened?
I'm coming to what happened. Just see page 40.
Page 40.
Yes.
Yes.
Page 40. Now, I'm not referring anything because detailed directions was. Kindly see page 40, just above letter, when Lordship is concluding the judgment with immediate effect. That was on 25th of September, 24th. And the prayer for stay, Lordship rejected it. Division bench on 6th of November, after detailed delivery. Kindly have a look at page 52, paragraph 25. Elaborate submissions from both sides. We do not find any reason to interfere with the order of the learned single judge. Still,
Higher up.
there are.
Higher up.
They are telling. When I go to Arjikor, very second day, Lordship delivered the judgment and directed that immediately.
Who are the condemneds?
The principal secretary, DHS, director of health service. They say unless official letter comes from them, we cannot.
They come from?
They use the word Shastro Bhavan. I've said in paragraph 12.
Achha.
This is I can understand that they want to taste it.
Yes, what is the next? I have to issue this notice.
That's logic.
Mr. Advocate General, are you for this matter?
Yes.
Tell me what is this? You are preempting the notice.
No. Thanks, Milord. First is, Milord, there is a contemplation to go before the Supreme Court.
Achha.
Number one. And number two, Milord, as my learned friend has said, that Milord, my Lord's judgment was tested before the division bench. Therefore, even if any contempt has it, it has to be before the division bench, not before the single judge.
Let us not go back.
That you may take a
Yes.
point.
But for the present, Milord, kindly keep it, Milord, after a week or so, Milord, in the meantime.
You know my time is limited. I cannot give you to go to Supreme Court. How much time is limited?
Well, this is
But I told me it has been filed today.
It has been filed.
Fine.
Provide me the number.
Give the number.
But in the meantime, I will be inviting affidavit from you.
But please record this submission of mine, two submissions. One about the SLP, the other is, Milord, according to me, Milord, the contempt would lie as on today before the division.
Order marches. Yes, Mr. Dhaw.
Hello,
How do you react?
paragraph 25.
No, there's recording division bench.
Yes, I'm answering to that. There are two situations. In some situations, the Honorable Division Bench, having found that this is the order, but there is to be little bit of curations, plus minuses. Now, this is the case where not even a comma full stop added. So this is not a case of merger at all. There are so many cases, because that's the reason I straight away went to 25. But there has to be, even as lawyers, my lord, whole justice delivery system will completely break down. I can understand anyone wants to taste, absolutely no difficulty. But I think, my lord, this should not be a submission for.
I will not be so hurried, though I should be, because I may not be conclude. But I think I will be getting that much of assistance from Mr. Advocate General, so that I can make it within a time, subject to you move Supreme Court, because you know very well mere filing of SLP will not operate as state.
No
So try to move it as soon as possible to get a finality of it.
Understand that everything is not in our hands.
No.
But still, I'll instruct him to take, Milord,
Well, there is
Because
I have- well, I have-
contempt is staring at your face.
Yes, yes.
Mere filing, I will not
Definitely
stop
not. Definitely
myself.
not. Definitely not. Definitely, I cannot say so. But at the same time, Milord, those line
Of
of
course, judicial propriety demands I will give you a reasonable time to test it.
the tasting part is everyone's right. There is no clash between tasting and complying. Kindly visualize this situation. Today, there are X number of doctors at Arjikor. If one is added, it is a good for everyone, including
know,
the state.
Mr. You may correct in an ideal situation. There is no, I could not express my mind, but he has to comply so long I am here. I know how to make the respondents
They would comply.
comply.
But what they want is this. They know how a surgeon, anesthesiologist who is not in the operation room, how he loses his accuracy.
Mr. Dhor, I am only uh, hoping and I have a full, I may repose confidence on Mr. Advocate General. I will not get the same feelings as the Honorable, the last Chief Justice has felt in a particular manner. To defer the matter not to have before me. But certainly,
For a tasting,
I
I
am.
have no difficulty. All
No,
I say,
he has to provide me.
allow me to work. When there are Lordship has delivered a judgment, division bench have delivered, nothing stops me. Why they are not allowing me to work? And they are not saying no. They said we need.
Today, I am not dealing with this, the objection of this going to, because it will create another offsuit.
Well, this is there are hundreds of cases. I never thought
I'm,
that
I will not.
Advocate General will take this point.
no, I am reminding Mr. Dhora, he's definitely aware of the judgment of Gojar brothers, which says that even if the division bench affirms the order of the learned single judge by a one sentence order, then also it should go before the division bench.
There.
Show me. Why should I bother myself? Show me now.
Gojar brothers না? আছে তো কাছে? Yes, but right now I came to know, Milord, that this matter is listed today.
Oh. এই কালকে রাখো। Please come. If that judgment, you consult that judgment.
I have. In
But
fact,
I'll also say, Milord, there is a larger bench judgment of our court of Justice Harish Tandon, Justice Shampar Sarkar and Justice Rabindranath Samanto, if I'm not wrong, which may have taken a different view, but finally, Milord, the division, I mean, the Supreme Court's judgment put.
If it is a very so clear, even a one-liner judgment rejection, that also
Even affirmation before the division.
The point is, I have absolutely no difficulty coming before your lordships or before
going
the
to the division bench.
I have to go before the division bench.
Now.
I'm requiring a one sentence, because otherwise what will happen?
No, of course.
It will be taken. Why have I come there? I don't want a
No, of course. That is why I'm keeping it tomorrow. Tomorrow, not today.
Wait, could it be Monday?
Judgment is ready in your pocket. Just bring it out.
এই এখনই দেখিয়ে দিচ্ছি তে আমাকে একটু এয়ারড্রপ কর
একটা লক্ষ্য রাখুন।
Because I was not able to read what Advocate General was reading. So I thought it was dark. I was informed
No,
there is a
it was
secret class.
judgment.
If that is put there, nobody.
Oh, except you.
Yes.
It is connected with your I.
No, nothing. It's nothing to do with Elon Musk. It is quite no link.
Mr. Advocate General, if you are convinced yourself, come on Monday, as you were saying, come on Monday. If you can convince yourself, that can be argued, argue. I will certainly, it is coming from Advocate General, I will give some credence. And if you don't find that this is not, and
No, but this point was argued before the division bench headed by Justice Devanshu Boshak in Boishaki Banerjee's case.
Because Supreme Court then modified.
it automatically comes.
Therefore,
It automatically comes.
well, I'll produce the larger bench decision.
No, Justice Boshak, as I know, did not entertain the contempt.
Yes, because it was modified.
It was modified. It was Toto.
Based on Gojar brothers.
Yes, if it is Toto.
Yes, because today,
affirmation.
sir, my lord's judgment has merged with the division bench's judgment. Therefore, what subsists today, as on today, is the division bench judgment. Because two orders or the two judgments from the same proceeding cannot survive. Any one will survive.
Let us. I know that. I know, Mr. Doctor. May I give it another illustration? Now, of course, suit court judgment merges with the appeal court judgment. Which decree to be executed? Which decree to be executed? Which will be the executing court?
But it depends upon a lot of factors. Where if it is, Millard, say for example, a decree, Millard, arising out of a, say for example, land acquisition appeal, it has to go before the collector or Millard, the lowest forum.
Of course, even in a general suit, even the appeal court modifies the decree. That decree would be of that court which has passed, and executing court would be that court who has passed the decree, not the appellate court, not even the Supreme Court.
But if it,
in a contempt, and there is a little bit of difference between a contempt and
that's a different thing.
Executing court.
Yes.
I'm giving a loose illustration to you. In case of execution, this will be the lowest court.
But that is where there's a provision in
the Code of Civil Procedure itself.
Yes,
you can make a.
You
can make it as an analogy. You can make it very surely that this is contempt is not a executing court. Is not. It is the.
Has been somehow not seen by the variety of courts in a very watertight way.
Yes, well, there's a difference of opinion.
Yes, because it is contempt. Essentially, the courts, they do not enjoy by passing an order, issuance of rule. Fundamentally, it is to see directions are complied with.
But nonetheless, the principal task is the execution, or to see the person who has violated the order.
It's a mixture. I would say it's a mixture. For an example, if the first part is execution, if that is completely ignored, then it would be a lifeless body to move on. It would be a pure technicality of it. I was also thinking, I understand there are point can be argued. I was putting a question to myself. Today, when there is not even a comma added in the judgment of your lordships, I really do not understand. Would it be a fit case to use the energy for arguments? Because fundamentally, whatever lordship has ultimately said, that has been appealed. No interference.
No, Mr. Dhar, I am not. You need not labor yourself for so many words. What he is showing, if the Supreme Court says, at the same time, he is fairly saying our special bench says no, it will lie in the order. But what he is showing, even a one-liner affirmation, the appeal court, that is the judgment what he is want to submit. If he is convinced, he will submit it. Otherwise, I will overrule his objection.
There are hundreds of judgments against that, but fine.
Don't multiply it.
I was only thinking this. I don't know. There are cases where we place judgments, but there has to be some nexus with the object. For what?
Mr. Dhar, that is why whom I am hearing, a senior advocate of this court and advocate general. It is obviously court can legitimately expect a relevant judgment would be cited. When the advocate general is saying even a one-liner affirmation, appeal court assumes the jurisdiction to deal with the contempt. Then I have to see that.
Even in a case where the language here by the division bench was not even there is a separate direction. The language was, we do not find any reason to interfere with the order of the learned single judge. Therefore, there is no independent directions by the division bench at all.
Absolutely. That is why I have given you the illustration of a decree which has been affirmed with some modification in the decree. But which will be the executing court, the appeal court or the trial court?
But executing court is always the lowest court.
And otherwise, I was also thinking there is no meaning of stay.
Or Mr. Dotto, to be precise, the court which has passed the judgment.
And I was also thinking this. There has to be some meaning has to be attached to the act of seeking stay of
Where I found it.
One liner. Read out.
It doesn't say one liner, but kindly.
First of all, Mr. Dotto, please convince yourself that this is a pointer to the judge.
I have read it earlier also. Please have a look at it. We can elaborate on this later on. This is 1974 to SCC 453. Please have a look to Milord, paragraph 11 first. The juristic justification of the doctrine of merger may be sought in the principle that there cannot be at one and the same time more than one operative order governing the same subject matter. Therefore, the judgment of an inferior court, if subjected to an examination by the superior court, ceases to have existence in the eye of law and is treated as one being superseded by the judgment of the superior court. In other words, the judgment of the inferior court loses its identity by its merger with the judgment of the superior court. Stated in this form, the principle may appear to be unexceptionable that the problem has many facets. What if the higher court dismisses the proceeding before it summarily without speaking order? Does the judgment of the lower court still merge in the unspeaking order of the higher court? What if the powers of the higher court are invoked in exercise of its revisional and not appellate jurisdiction? Does a judgment or an order passed in exercise of a severely restricted jurisdiction like that under section 115 of the code wipe out the existence of the decree or order passed in the exercise of wider jurisdiction as may be exercised by a court possessed of a suit? Does it make any difference to the application of the doctrine of merger that the higher court has not modified or reversed the judgment of the lower court but has merely affirmed it? These nuances had once raised issues on which conflicting views were expressed by courts. Over the years, the area of conflict have considerably narrowed down, and most of the problems touched by us has been resolved by this court. It is only proper that we keep ourselves within the bounds of the issue arising in the case. We are not concerned to determine whether a decree passed in a suit can merge with an order passed in exercise of revisional jurisdiction, because the decree of the trial court in the instant case was challenged first by an appeal filed in the district court and then in a second appeal in the high court. We are also not concerned to determine whether the decree passed by a trial court can merge in an unspeaking order passed by the higher court while summarily dismissing the proceeding, because the high court has given a considered judgment after a contested hearing. The principle, therefore, that there is no decree as such of the appellate court if it dismisses the appeal for default for appearance or for want of prosecution, or on the ground that the appeal has abated or is withdrawn, or that the appellant has failed to furnish security for cost as provided under Order 41, can have no application to the instant case. Nor indeed are we concerned with that class of cases in which the suit covers a horizon wider than the appeal, which happens when only a part of the decree passed in the suit is carried in appeal to the higher court. Here, the decree in its entirety was challenged before the so and so. Then we have section 17D, Millard. I skip over that part. 14, 15, kindly skip over. Then please take 16. In cases where the decree of the trial court is carried in appeal and the appellate court disposes of the appeal after a contested hearing, the decree to be executed is the decree of the appellate court and not the trial. In so and so, the Privy Council, while holding that the limitation of 3 years within which an application for a final decree must be made runs from the date of the decree from the appellate court quoted with approval in the statement of law contained in the judgment of a learned judge of the Allahabad High Court to the following effect: when an appeal has been preferred, it is the decree of the appellate court which is the final decree of the cause. Privy Council also adopted the statement contained in a judgment of so and so to the effect: when the munsif passed the decree, it was open to the plaintiff or the defendant to accept the decree or to appeal. If an appeal is preferred, the final decree is the decree of the appellate court of final jurisdiction. When that decree is passed, it is that decree and only that which can be made final in the cause between the parties. Thus, when the decree of the court of first instance is confirmed by the High Court and the latter decree is confirmed by the Privy Council, the decree capable of execution is the decree of the Privy Council. In that case, the decree passed by the district judge awarded future mean profit to the plaintiff. That decree was reversed by the High Court, confirmed by the Privy Council. When the matter came back in the executive proceedings, the Privy Council held that the decree which the courts had to execute was the one passed in it in 1895, and since that decree, the district judge's decree was confirmed. The decree of 1985 clearly carried the mean profits up to the date. An application of this principle, I don't think whether this would be required. Then, the merger principles are being discussed from para 20 onwards. So 11 to 16, these are the relevant paragraphs.
But Mr. Dotto, as I had a cursory look, I may miss the point.
Yes.
It was the decision which of the decree is executable.
Yes.
Backdrop, the 17D was taken care of by the High Court while in appeal. Then which decree would be executable decree? But possibly we are on the forum.
Yes. Now, whether this Gojar brother is applicable in contempt jurisdiction or not?
No. Let us sure that illustration. I unknowingly I have given this. Which would be this? Supposing in the appellate court modifies the decree, then again execution. Who would be the executing court?
Para 16, first sentence. In cases where the decree of the trial court is carried in appeal and the appellate court disposes of the appeal after a contested hearing.
Yes. Decree to be executed is the decree of the appellate court, not this
trial court.
Even today, supposing, even I go that, the appeal court modifies the decree. Then contempt of that court, or I don't know, contempt jurisdiction cannot be equated to the executing jurisdiction. But here the case is very, and which one of the, if you go the first, I don't know.
In this case, it is different. But principles are not laid down.
No doubt that this is the decree of the appellate court. The context was 17D came depending appeal. The suit decreed in August 67. 17D came later on.
Right.
The High Court modified decree that this question is which is the decree. Very well, you satisfy me.
But I'll come back on Monday, but I'll also will not cite the special bench decision. Otherwise, but I'll be unfair to
No,
the-
what? Yes, whatever is there, but obviously, no.
And apart from that, it is, according to me, willful and deliberate violations, which has got nothing to do. This really touches.
Yes, first of all,
justice
if the
delivery.
initial point goes in his favor, obviously you have to go to division. If it is overruled, then I will certainly expect Advocate General will give me a definite answer before the harshest step is taken. They are high officials. Before any harshest step is taken, Advocate General will take certainly. He has got their avenues. First of all, this court has no jurisdiction to entertain this. Second is pending SLP. Pendency will not. This court will not stop merely of the pendency. That I am making it clear. File it, get the stay, and get everything done. Then Monday, come Monday, Mr. Dhar.
But if your lordship may kindly pass a one-line order, it may not help my counterparts in Delhi to Millard expedite things over there. Because on mentioning Millard, Millard matters do not get.
Today I am not. Today I am not. Today I am not. You come on Monday, I will consider
Right.
all this.
Mentioned.
It is an application hearing. Which one? Which one not have it?
Seven hours of
But I have a prayer today, Millard. Mr. Bhattacharya is here. Millard, yesterday, Millard, the Honorable Division Bench, Millard, has passed an order. Millard, I would like to, one day, if your lordship permits us to come back tomorrow, but I would like to go through that order. I mean, the judgment of the Division Bench.
In
If
that-
required, Millard, I may have to cite it.
Which one?
But in the Priyanka.
That's a different issue.
No. I
Priyanka?
Priyanka Noskor, Millard.
Which
Where,
one?
Millard,
Item number?
no, it's not here. But what I'm trying to say,
In respect of which matter you are talking about?
Millard, in respect of this Jalpaiguri matter,
Acha,
which has been
acha.
called on, Millard, I'm submitting, Millard, in a case which was decided by the Honorable Division Bench yesterday, which was a case of corruption.
This is not a case of corruption.
Wait.
And what is the bearing in it?
That's what I'm saying, Millard.
If you want to give it, but I cannot wait, Mr. Dotto, this is a serious condition. You may address it tomorrow, but I will conclude it. I will not. I'll be leaving a scope for you. You may point it out, but I don't think that I can afford to defer the matter anymore.
I need to not do that, Millard. Quick, let there not be any hurry, Millard.
No, I am in hurry. I'm telling you, I'm giving you much time.
No.
Everything is concluded. Now I am on this.
Millard, if there is a subsequent development of law, because your lordship is
Show
still
me.
in the matter.
Show me if there.
I can understand where the hearing is concluded. That's something different.
No, almost concluded because Mr. Bhattacharya was not there yesterday. He appeared in online, but offline he was not available. I understand what is the reason behind it, but don't give me that feeling that you want to avoid me. Don't give me that feeling. Don't give me that feeling. I will not allow this. It's very well come tomorrow. On your request, I may keep it to be mentioned tomorrow on this point if you want to. But I do not want to leave this institution with the feeling the lawyers are avoiding me.
No, why will lawyers avoid?
Avoiding?
No, I don't. I can take responsibility for him, Millard. At least, Millard, Vishnu.
No, not for him. Not for him alone. But differing in this way. Yes, where is Mr. Somo Majumdar? Can you inform Mr. Majumdar? I have one query from him. A little Jalpaiguri. Very well, you cite if you find relevant.
I'll go through it, but I just had a cursory glance.
Go through it. If you have got any impact, It is my duty and your duty also to see that.
Lordship will come back to 7 or no?
7, what is 7? Matter 7?
7, my lord. There is.
You are appearing for?
For the ICC.
Yesterday, I'm telling you, yesterday she has moved it. The appellate, which one would be the appellate forum is yet to be decided.
Correct.
Right? By the time the penalty proposed to be imposed upon that cannot be.
Since you.
Whatever the penalty. That forum is before which will be the forum? It will be before the division bench. I am not going to go into that question, which would be the forum. Appeal pending?
No appeal.
Appeal pending.
I am not appearing for the college concerned. I am appearing for the ICC. I have found it to be malicious. So I have given my recommendations. So my role is limited to justifying my decision there.
Justify
That decision has been challenged.
in appeal.
Correct. And that
But the appeal court says that I am not the appellate forum.
I've seen that. I've seen
Right?
Yes.
Now, the decision of the learned single judge, you are the appellate forum.
Right.
You are the appellate forum.
The Labour Commissioner.
You are the appellate forum. Then appeal taken out.
I understand.
Appeal pending. The remedy of appeal would become illusory for the petitioner.
But appeal in the eye of law, because your lordship, two minutes.
May
May
I just say only one thing? Well, Lordship what Lordship is saying, that would be the first reaction of it. Anyone will react exactly in that way. But Lordship may kindly consider just two things. One, availability of appeal versus a good case where a stake.
I am not going to test it. I am not the appellate forum.
That
The only grievance is that the decision of the committee suggesting or proposing some punishment on the petitioner is required to be tested to an appellate forum, which is provided in the statute or somewhere. Right? Now, the appellate, who will be the appellate forum? There is a dispute. Pending that appeal, the punishment cannot be imposed.
College was not made party in the appeal. Number one, there is the appeal.
Whatever the appeal will fail.
But the punishment is, I can understand if the punishment really affects in some way.
No punishment, even say pay 1 paisa, nothing.
There is no pay 1%.
Whatever, if there is no punishment, withdraw the punishment.
But
Then
censure, my lord.
only censor,
Correct.
minor, no appeal prefer. Kindly similar.
It is like
Correct.
this.
Nothing.
But against that,
Nothing.
appeal lies before the
You
university.
cannot touch the petitioner.
Yeah.
Pending appeal, you cannot touch the petitioner.
Only minute. Subject. Let him
Mr.
say minute.
Mr. Dhar,
Time.
Mr. Dhar,
May
I'm open.
request this, may I-
Yeah, that impression, what she has given to me, this is the
I
scenario.
was not there. I don't know the.
This is the scenario.
This is the same.
If there is anything more,
May I come back because I have one completely different prayer. The petitions that I have received, the large portions I can't read because it's not legible at all. May I come back, my lord?
of course, I can give you, but I'm making it clear. The
understand.
prima facie impression, and this is the impression.
Yes.
A party who has a right of appeal,
But I have
the
understood.
appellate forum is not there. There is a dispute with
He
regard
gets
to
the
which
benefit
is the
of
appellate.
Milord,
Whatever punishment.
Milord, I bow down to my lord, Milord. First of all, Milord, so far as Mrs.
Let us reserve. We come
let
back.
us reserve.
Yes, that's
Let us reserve.
We come back.
বারণ করছে যখন।
On
Is there anything more to add? Then add.
Yes, more to add. More to
so
add.
should we
Not on the merit of the appeal.
Not merit.
Not
the factual incorrectness in the Milord, because she could not be, because she has not completed her submission. That is why no fault is attributable to her. She has said basic thing, but there are more to our
What
eyes.
is the more?
More means, Milord, first of all, the act says within which time, Milord, the appeal should be preferred.
I'm not on that.
No.
Get the appeal.
The appellate forum is there. She has not preferred any
Yes, my
appeal. She has not preferred any appeal. Had it been a case-
Wrongly preferred. Wrongly preferred.
Not wrongly.
Wrongly preferred.
Not wrongly, Milord. Kindly, Milord, allow me this.
Mr. Bose, I am not going to touch
Let us not-
anything.
Let us not, Milord, let us not, Milord, your lordship, Your lordship has very
কালকে কি
limited
আছে
time,
গো?
my lord.
I don't
I
know.
will not disturb your lordship.
Tomorrow, if it is fixed,
No, kindly.
what is the urgency means? What is the
It's
In June
No,
2025, my lord.
June 2025.
one day she will not suffer for one day even. If she does not get the appellate forum to challenge the decision.
That is not the law, my
In the
lord.
month of
Appellate
May,
forum
you
is
are
there.
informed that
Kindly have the child, my lord. Mr. Dhar, learned senior advocate, my lord, when he has requested that he would come back, I am not, my lord, creating an impediment. Just make it a not day.
I will try to accommodate tomorrow, but tomorrow is a very difficult day.
No, kindly you
Uh,
should not keep it till tomorrow.
তাহলে মঙ্গলবার করুন। মঙ্গলবার
Maybe on
বিকেলে
Monday.
করুন।
The other matter, Lordship, that is on Monday. Can I come on Monday? Lordship need not pass any order.
মানডে চাপ থাকে
Monday.
what Mr. Advocate General has shown the judgment, kindly give me that citation. No, citation, what he has shown.
For
74 to
yeah,
Just now, yes. Huh? 74, 1974, 2 SCC, 453.
teaching matters.
I remember. Very well. Not this week.
Monday or Tuesday.
Come on, not this.
one line.
এটা লিখিত এক
One
কথা
line.
document।
One line.
What one line order?
Tuesday।
Stay, I can only pass stay of this order of the imposition of the power. Only stay. She is entitled to that, I can pass.
Lordship need not.
10th possible। 10th possible।
Possible subject to stay on consent.
সোমবারই থাকবো।
On consent stay.
সপ্তাহের প্রথম দিন। No on consent।
চলো ডাকো।
একটু আমাদের বলতে দেবো। সঙ্গে
Sir, please come forward. Where is Mr. Bhattacharya? Because I do not want that I should repeat your submission before Mr. Bhattacharya. Just give me a 2 minutes break.
Yes, yes.
Mr. Majumdar, just explain me how the schools under GT are private school. Just that part. Nothing more, nothing less. It's a private school. It's not at Article 12, but private body functioning public duties amenable to jurisdiction. What we are striving at, I want to understand. But don't let it to your junior's hand. He has repeatedly repeated the same thing in your written notes.